Hello, welcome to the webinar, Cannaployment, an overview of sticky cannabis employment situations, internal investigations, terminations, and protecting trade secrets. My name is Jim Ickes, and I am an attorney at the law firm Zuber Lawler. Zuber Lawler is one of the most selective law firms in the United States, representing clients throughout the world from 8 offices across the country. Zuber Lawler focuses on emerging industries and technologies, including cannabis, psychedelics, clean tech, cryptocurrency, artificial intelligence, and many more. I'm honored to have several representatives here with me today from Greenleaf HR and FlowerHire to kick off our discussion. Before we dive into it, though, here is a quick disclaimer. The opinions expressed are of the individuals and not any companies associated with this presentation. We don't encourage the use of illegal drugs. Consult your healthcare provider and attorney regarding the use of cannabis. Nothing in this presentation creates an attorney or fiduciary relationship. Please seek the advice of your own professionals. So first off, let's introduce our panelists. Let's go to Greenleaf.
Thanks, Jim. Good morning, everybody. My name is Greg Callan, and I'm a business consultant with Greenleaf HR. Greenleaf HR is a HR outsourcing company for the cannabis industry. We are part of the 4th largest HR outsourcing company in the United States called Venture Employer Services. And we provide customizable solutions for back office administration, including payroll solutions, HR, workers' comp, and employee benefits for small and medium-sized businesses.
I'll jump in. Hi, I'm Beatrice Runyon. I'm the AVP of HR Compliance for Greenleaf HR and a colleague of Greg's, and I'll turn it over to Jason.
Everybody, good morning, good afternoon. Jason DeSense. I'm a managing partner at FlowerHire. FlowerHire is the #1 recruitment firm in cannabis. We service all companies within the industry, from either startup or large MSOs, and we also are the largest HR advisory firm as well.
Hey, good to see everyone here. I'm an attorney at Zuber Lawler in Los Angeles. Happy to be here. I've been doing cannabis-related law in California since 2009. Initially, my work was mostly criminal defense, and now it's shifted to more regular business law, doing regulatory compliance, employment law issues, commercial litigation, deals and contracts, as the industry has kind of become normalized. It's been fascinating to watch the industry evolve and mature over the years. It's still a very interesting industry to work in, given the conflicts between federal and state law and the interesting legal issues that implicates. And it's interesting to see new markets still opening up across the country, going through the same process as California went through several years ago, creating lots of opportunities for people in the industry to expand and grow. But I'm happy to be here to talk about these interesting issues today.
Fantastic. Well, let's dive in here. But first off, I want to encourage everybody out there who's watching this to please submit questions. We want to make sure that this webinar is useful for you. So please feel free to submit a question over the chat, and we'll make sure that we get to it. But first off, we're going to talk about wage and hour. I see on the plaintiff side, over the years, many law firms have popped up that basically do wage and hour litigation on the plaintiff side exclusively. So my first question is to you, Beatrice. How can cannabis businesses effectively address wage and hour law violations?
Yep, thanks, Jim. Really, the best way is to not have a violation in the first place. But we all know that isn't reality. So one thing that cannabis companies need to remember is that even though they may operate in a really unique industry, it doesn't exempt them from their legal responsibilities. You know, some of you may recall there was a somewhat relatively recent case, Helix, where an employee filed a collective action against the Fair Labor Standards Act, or FLSA, where he was trying to say that he and his coworkers were misclassified as exempt from overtime. And then the company asked to dismiss the case, saying that the federal court had no jurisdiction to hear the case. And then the 10th Circuit Court of Appeals said, no, just because the employer isn't excused from complying with federal laws, just because their business practices are federally prohibited. So one of the first things that you need to do, given all of that, is you still have to follow the letter of the law. And so you need to make sure that your employees are classified correctly. You want to make sure to review your job duties and responsibilities to make sure, do they really truly qualify as exempt or non-exempt? And then if you have employees that are exempt, you want to make sure that you're keeping an accurate record of all their hours worked, their overtime, and make sure you're paying them accordingly. So, Greg, do you have some thoughts about some best practice for ways to keep those accurate records?
Yes, thanks, Beatrice. We have a couple of different timekeeping solutions that can help all verticals of the cannabis industry, and it's important that, as you mentioned, to be able to keep accurate records, whether you're a dispensary and you're paying commissions, or if you're in distribution where you have delivery and you're paying mileage, or going back to the dispensary where if you have a delivery exposure, or even the cultivation vertical where you have piecemeal. So it's important to be able to track and keep this information so you can ensure compliance on that end. And we have the technology to provide that resource to you.
Awesome. Thank you. Yeah. So in addition to making sure you're keeping accurate records, you also want to make sure you're doing regular audits of your pay practices, and correcting any discrepancies as soon as you discover them. Make sure that if somebody was paid incorrectly, you make them whole right away. And you also want to make sure that you're communicating your policies and expectations, giving preferably written guidance on overtime, breaks, anything that's relevant to your employees needs to be in writing. So are there some ways, Greg, that is a good way to communicate this to the employees, a handbook or something along those lines?
Yeah, I mean, you hit the nail on the head there. I think it starts with an employee handbook. That's the employee's roadmap to success there, and that lays out the expectations of the employer itself. Excuse me. And then secondly, with with job descriptions, and then last but not least, your training. We have an online platform called Mineral HR that has more than 300 different training topics, from state mandated trainings all the way through supervisory leadership and down through OSHA and safety trainings. And that can be a valuable resource for you as an employer. And the good news is all these trainings can be started during onboarding. So then you're compliant from the get-go.
Yeah. Perfect. Yeah. And really the best way to prevent wage violations and protect both the employees and the businesses is to be proactive. So that's a great suggestion.
Fantastic. So I know wage and hour law violations are important in HR, under our HR violation category, but also we need to prevent discrimination and harassment. So I'll go to you, Jason. What strategies are most effective for preventing discrimination and harassment in the workplace?
Yeah, I really think Beatrice and Greg hit it off the head right away. First of all, having a compliance handbook that addresses that is not appropriate, and making sure that the employees have read that and actually have signed off on it, so you have documentation of that. That's really step one. But really, a lot of this is all about training and making sure that your leaders are trained on how to confront these things when they come at them from their employees, but also letting the employees know by trainings as well. Again, a lot of the systems like what Greg and Greenleaf offer have these courses and modules in there from a compliance standpoint that you need to do it every year as a mandatory training every year, along with all your other documentation, because just getting in front of them once and letting them forget it is not the right way. You got to kind of have to rinse and repeat when, just so that way folks understand what's in and what's out, because everyone always doesn't really understand. To me, it's obvious, but not to everybody. I guess maybe I've been in HR too long. And quite honestly, a lot of companies also institute what's called an anonymous hotline, where you can call in with a complaint and not give your name. But, again, HR is usually the one with legal has access to that. And it's another way where you can document and actually submit a claim of harassment. So that way the employee doesn't feel intimidated or feel like any retaliation for commenting. But again, another thing is open door policy, I always say. So leadership should be meeting with their staffs on a regular basis, but they should always be inviting and saying, look, if you ever have a challenge in the workplace, my door is always open. And making sure to remind them of that, because again, if leaders have the right training, then they should have the right way to respond, or at least if they know or have been acknowledged that there has been a harassment or could be, they next need to make sure that they notify HR and get them involved HR can actually file some kind of claim and then go through the investigation process, which we'll probably talk about here in a minute. But it's really important, again, just to kind of go over that, is make sure you're having that leadership presence and that open door policy. Have a hotline. It doesn't take anything really to set that up. Very easy, low cost. And then also making sure that, the training is appropriate for all employees, and then especially a little extra training for managers on how to handle those situations if they're actually confronted with them. So those are the strategies that I work with my clients, and they work very well, and they have worked tried and true for many years, both inside and outside of cannabis. So that's the best approach, in my opinion, for those strategies.
Fantastic. Thank you, Jason. And we have a question that just came in on our Q&A, and it's from somebody with a sense of humor. So here's a sticky question. What is the best way to introduce to HR departments of employers on how to add cannabis and or psychedelics as an employee benefit? So whoever wants to tackle that one, go right ahead. Beatrice, you said you'd like to answer it?
No, I'm just joking. I'm happy to answer. That is really challenging because you want to make sure if it's a benefit, you're just following, the right protocol on how to introduce it. If it's a benefit, you present it, you make sure it is, that you're being fair on how you're presenting it to your employees, that you want to make sure that, if you're offering it to one group, you're offering it to everybody. You can't, pick and choose who gets the benefit, who doesn't, unless you do a carve out. So, it really is going to be case by case. Each company can determine how they want to, set that up, but it needs to be fair. I don't know, Jason, if you have any thoughts on other best practices.
I do. I've actually been confronted with this several times. The reality of it is you should always, and we'll talk about this a lot in today's session, and we have in other past compliance. First, know what you can and can't give to your employees for free or as a benefit as an organization. So your state law will actually have those mandates in there. A lot of companies have loyalty programs for their employees, so that employee discount. That is very highly encouraged. It's a really nice way to give your employees a benefit of getting the product at a cheaper price. So I would encourage you to do more of that. However, there are also plans where people are able to give out cannabis, I'm not familiar with psychedelics, so I'm not going to speak to that. But the cannabis side, I have seen people that they, in some states, are allowed to penny it out or something, and then they can get it to the employee. But first and foremost, please follow state compliance. They will have regulations around what you can and can't give. But I would still encourage a loyalty program at a discounted price, just like they do outside of cannabis. If you work somewhere else, a lot of companies give you discounts. If you work for Goodyear Tire and Rubber, they give you a discount on tires. If you work for an auto company, they give you a discount on a car. Same thing here is that concept.
It's definitely a new world we live in when we're talking about cannabis and psychedelics as being an employee benefit. But it sounds like it's an area probably where the law needs to catch up a little bit in that area. And so next question's for you, Raza. How can cannabis companies ensure compliance with state and federal employment laws? Well, that's a big question, but.
Oh, sure. I'm happy to get into that. And just wanted to speak briefly on that last question.
Sure.
In California, at least, it's illegal for a company to give away cannabis as a promotion or marketing tool. It is legal under California state law to furnish cannabis up to a certain amount, though, outside of the commercial context. So I would say an employer giving away cannabis to employees, it's kind of in a gray area. And I would reiterate the last suggestion that maybe a discount, if you sell it for 1 penny, that's, kind of a loophole around the law that is allowed, at least in California. But I would advise you to look at your individual state law if you're thinking of offering cannabis-based incentives. I know a lot of employees may appreciate that, but you want to make sure you're doing it properly in a way that's not going to get you into more trouble as an employer. And just shifting in general to how can cannabis companies ensure compliance with state and federal laws. First of all, just as a general observation, cannabis companies often have a lot of problems with compliance in employment more than other industries. I think it has something to do with cannabis operating in the illicit market for so long during all the years of prohibition, with all the payments made in cash, no records kept because they were incriminating, and people were unable to go to court to enforce employment laws when the entire business enterprise is illegal. But it's been a really quick turnaround. Now we have 38 states with medical marijuana and 24 with recreational marijuana. And each of those states has detailed cannabis regulations. and the industry is suddenly subject to enforcement of all the general employment laws in the courts and administrative agencies. So the industry has gone from basically totally unregulated and underground to highly regulated, kind of going from 0 to 60 in a few seconds. So it's been kind of a culture shock for a lot of people in the industry, a big learning curve. But for companies, it's important to try to get this right because there can be really huge liabilities, especially when we're getting into kind of systematic wage and hour violations and so forth that can be brought as class actions. So how do we get a handle? There's all these different laws, federal, state, and local laws. What's the best way to approach compliance? First of all, under the Supremacy Clause to the U.S. Constitution, federal law supersedes state law if there's a conflict. But state laws and local laws can provide more protections than federal law. So there's certain federal employment laws that apply to all companies across the country. There's a federal minimum wage, there's federal overtime laws, federal discrimination laws, immigration laws that come into play as to who you can hire. But state and local laws often provide additional, more expansive worker rights not covered by the federal law. For example, many states have higher minimum wage, often much higher. In California, the minimum wage is $16 versus $7.25 at the federal level. States can also have meal and rest break requirements. In California, there's a requirement to have unpaid meal breaks after a certain amount of time and paid rest breaks every so often. And it's important to get that right because that can lead to really huge liability if you don't pay attention to that. Also, states can require reimbursement of all business expenses, whereas under federal law, you don't necessarily have to as long as you're paying minimum wage. State rules can have different overtime rules. Under federal law, over 40 hours a week has to be paid overtime. But under state law in California, you have to get paid overtime for over 8 hours in a day. So definitely look at your state law there. Also, sick and vacation days, that can vary based on state law. And states can have different categories of discrimination. Some states outlaw discrimination based on marital status, sexual orientation, gender identity, political affiliation, or activities. So it's important to look at the state rules there. Also, for sexual harassment, some states have particular training requirements that managers have to go through every so often. If you skip that, you can open yourselves up to more liability for sexual harassment. There's also different tests for independent contractors versus employees. That's an issue where a lot of cannabis companies seem to get it wrong and misclassify people as independent contractors when they should be treated as employees. But different states have different tests for that. We'll get into that a little bit later. And then also exempt versus non-exempt, what type of workers have to be paid overtime versus which ones can just be put on a straight salary. It's important to look at state law for that. So in terms of how to go about complying with all of these kind of patchwork laws, the first is to have written policies and procedures. It's important starting out that you put things in writing. This is first of all, it's a guide for everyone in the business how to follow the law and what to do in different circumstances, but it also gives you ammunition if you are sued by an employee, which usually happens to most successful businesses at some point. Then you can go back and point to the policy, say that you didn't have any systematic violations, that there may have been a rogue manager or something that was ignoring the policies, but it's important that you can point to something in writing to show that you at least had the policy in the first place and there was no unlawful intent. This can also help prevent class actions to the extent a manager is treating employees poorly, not giving them the right breaks, et cetera. You can prevent a class action potentially if you show you had a policy and there were deviations maybe sometimes, but it wasn't a kind of system-wide policy that violated the law. Written policies, they should cover kind of the major areas that come up in litigation: discrimination, harassment, drug testing, when's that appropriate, safety regulations, wage and hour laws. So how do you get that policy? How do you get those policies, that handbook? You don't have to reinvent the wheel. I would advise businesses to hire an attorney at the beginning to help review the employee handbook and written policies, maybe update them. It's important to have someone who's familiar with both the employment laws and cannabis laws, because the cannabis regulations oftentimes impose different considerations that don't apply in other industries. And it is helpful sometimes to start with a set of written policies or employee handbook that was used by another business in the same field, in the same location, But again, because the state laws differ, you want to look at something in your same state and the same industry, but you can sometimes use those as a starting point. But it's important to review and update them as appropriate because laws change. Local and state laws can vary widely. And the highly regulated nature of cannabis businesses and federal state conflicts of laws add wrinkles that don't really apply to other types of businesses. So just having an attorney take a look at the beginning to update your policies that can be used later to help as evidence to help minimize liability, to show that you're trying to do things the right way, and a little bit of money spent up front can help avoid really major liability problems in the future. Also, it was mentioned you have these written policies, but it's important to have some kind of training to managers and employees. You can just do that right at the beginning of employment. Have them sign off on policy documents to show that they understand them. And again, these can be used to help prevent violations and also use as evidence. If there's a potential case, it can help to show that the employees and managers were trained on these policies. And then it's a good idea to have periodic audits of your HR policies, maybe once a year or whatever, just periodically take another look to make sure there's no systematic problems that are kind of festering and growing larger. Laws change over time. Companies can fall into bad patterns just by inertia, where they're ignoring policies that exist but aren't really being followed. So having these periodic checks can be important. And also maintaining records, hours worked, meal and rest breaks, performance evaluations if there's problems. That's all important. Something that's often not done in cannabis because keeping records used to be used to incriminate people. But now detailed records really help avoid liability problems. And you can rebut allegations of legal violations if you could point to the records. Otherwise, it can turn into kind of a he said, she said situation. Also, it was discussed, provide a mechanism for complaints so employees can report violations and issues can be addressed before they become major problems. Cases can get a lot worse if there's evidence that the employer got warnings about a problem and then ignored them, or even worse, buried them and tried to cover them up. So there should be some process for people to raise complaints and to have those reviewed and assessed according to a certain procedure. And then the final issue, just in terms of compliance that a lot of cannabis companies seem to have problems with, is tax laws, including payroll taxes, income taxes, et cetera. Oftentimes in the industry, workers are misclassified as independent contractors when it's clear they should be classified as employees. And employers for employees, they have to withhold and deposit income taxes, Social Security taxes, Medicare taxes from the wages to the employee. And the employer also has to match the employer portion of Social Security and Medicare taxes and unemployment tax on wages. Generally, an independent contractor, none of these taxes have to be withheld or paid by the employer. So if you're not classifying people right, you can get all of these tax issues wrong, and that can create a lot of problems down the road for the employer. And different states use different tests for deciding whether someone can be an independent contractor. California uses something called the ABC test, where there's three separate factors. The worker, first of all, has to be free from the control and direction of the hiring entity in connection with the performance of the work, both under the contract for the performance of the work and in fact. Second, the worker has to perform work that's outside the usual course of the hiring entity's business. And third, the worker has to be customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. A lot of people just kind of ignore this test and just call people independent contractors, I think, so they can avoid having to pay taxes. But it's important to pay attention because liability can really stack up if you don't. Other states like New York use a different common law test. It mainly just focuses on whether the employer has does duties free from supervision, direction, and control. It's a more loose standard. So in some cases, in some states, it's more defensible to call more employees independent contractors. But just take a look when someone's coming on, look how they should be classified, and try to make an intelligent decision, because if you get it wrong, it could lead to liability going forward. And I'll turn it back over to Jim now. Thanks.
Okay. So we'll move on from HR violations to another very popular subject, and that's trade secrets and confidentiality. So let's go with you first, Jason. How can cannabis businesses identify and protect their trade secrets, and what are the legal consequences of not protecting them? And if Raza, if you want to jump in on the back end of that, that'd be great.
Yeah, thanks, Jim. This one's always comes up, I feel like, a lot with folks, which is why, and we'll get into the next question, either non-disclosure or non-competes, why companies tend to put those in or try to put them in when they really need to think not to in some cases. The reality of it is every employer should have a confidentiality agreement as well as trade secrets, where an employee should sign it on their first day of employment, along with all the other documentation and policies, as Raza mentioned earlier. So that way they've read and understand what's confidential information. Even after you leave employment, you still are bound by those confidential documents. So that's why companies put them in, and it's a protection for the company. So, because in cannabis, it's sticky. And again, I'll let Raza address this, but IP is not something you can protect federally per se. For cannabis, I know at the state level there's some options, but you can put confidentiality agreements in there. They are legal. They all, and again, Raza will confirm that, but they all protect the employer. But it's also to protect the employee, so that way they don't go to another place and actually, divulge those secrets over, because it is not their right. It's not their property, intellectual property either. So I highly encourage put in the handbook, which everyone does, as well as making sure people have signed off on it. And that way you have documentation to clearly prove that that employee has actually agreed to that. I'll turn it over to Raza.
Yeah, I would say for trade secrets, it's important for any business to think about kind of how do they want to protect their competitive advantage? What is it that they've developed at their business that kind of gives them the edge over other companies? That could include formulas, processes, customer lists, marketing strategies, any other type of proprietary information that you've kind of built up in your company and that you think really helps you give you an advantage over the other companies. And then it's important to document and label them. If information is publicly available, it can't be a trade secret. But if it's work and ideas that you've developed within your company, it can be protected. So just think about what information you'd like to protect, label it first of all. And then second, have some kind of confidentiality measures in place. These measures both prevent the trade secrets from being disclosed, and the event of a disclosure, it kind of bolsters the point that these are actually trade secrets that are protectable. The fact that you took measures to stop them from leaking is one of the elements courts look at in determining whether there's a trade secret in the first place. So as was mentioned, have employees sign an NDA, non-disclosure agreement, right off the bat. Just have that be part of the employment document signed at the beginning. Have passwords on computers to access certain information, security measures like that. Have policies maybe that access is limited to certain information on a need-to-know basis, so only certain managers have access to it. And then take action against people who violate the confidentiality agreements or misuses the trade secrets. And then NDAs, often it's called confidentiality agreements or non-disclosure agreements. They're basically used interchangeably. NDAs are often used more in business and legal settings to protect trade secrets, client lists, and financial data, that kind of thing, while confidentiality agreements you see more in kind of employment or personal situations to protect sensitive information. But either way, it's the same idea. They sign something at the outset. They're not going to disclose certain categories of information. And then if you don't protect these things, they could lose their status as trade secrets. You won't be able to enforce the protection. You'll lose your competitive advantage potentially as employees take your secrets to your competitors. And you can end up in costly litigation trying to pursue damages. So just to summarize, identify, label what you want to protect, and then have some kind of confidentiality measures in place through an NDA, passwords, that kind of thing. And that'll lay the groundwork to stop employees from taking sensitive information and taking them to competitors.
One other thing I think is important to mention, I know I've seen a lot of clients in the past basically try to designate everything as confidential to protect everything that way. But I think when it comes to trade secrets, it's important to be specific and really isolate what is confidential and what isn't. And as Raza indicated, have that information be on a need-to-know basis. The best example of a trade secret is they always talk about the recipe for Coca-Cola. Not everybody in Coca-Cola has access to that recipe, I'm sure, and I'm sure it's highly protected. So, in order to get the protection, you got to keep it like a secret. And the other thing too that I think is important to add, and in our digital age, every day we see a data breach in the press of some sort. There's certainly an overlap between trade secret protection and information security. Many organizations don't protect their information like they should, but you definitely should, in the cannabis industry, as it continues to grow, make sure that your networks are adequately protected and your employees are trained on how to protect the information of the organization. So on to the next question. What steps should a cannabis business take if its trade secrets are stolen or leaked? Raza, you want to field that one?
Sure. So what do you do? What are the steps you should take? First of all, you should find out who was involved in the leak, what trade secrets were compromised, how they were accessed or disclosed, and then take steps to contain the breach. If someone internal was releasing these things, potentially terminate them, discipline them, secure the electronic system, disable access to confidential information, put in place security measures to show that it doesn't keep leaking. And then create a record, document the breach, who discovered it, how did they discover it, who are the witnesses and suspects, create a written report kind of summarizing your findings, and get witness statements for future use in case you end up in litigation. Memories can fade over time. It's important to put things in writing. And then it's important to discuss it with the senior management, legal counsel, IT department to coordinate and address the problem systematically. And then you might think about notifying law enforcement if there was criminal activity like hacking or something like that. The police report might cause the police to investigate it and help you take action against the perpetrators. It can also be used as evidence later on that this happened and it's documented in this report. And then sometimes it's appropriate for a company to take actions in response to a leak of trade secrets. You can start with a demand letter. A lot of times, demanding that someone return certain information or not use it. And then you could potentially do a civil lawsuit for trade secret misappropriation, or you could go into court and try to seek an injunction to stop someone from using certain information. You might consider also issuing a public statement to correct any misinformation out there and avoid damage to relationships if the leak might have caused problems. And then just to periodically review and update the security measures if there were certain deficient measures that caused a breach. Look at the contracts and agreements with employees, contractors, and vendors to ensure there's appropriate NDA provisions in there, because those contracts can be important later on if it turns into a legal situation.
All right. I think we covered a lot in trade secret. So I'm going to actually bounce to some Q&A questions that we have coming in, which is great. The first one, if anybody who wants to field this one, but how does the philosophy of social equity apply to the new hire employment sector? Any of our HR pros want to jump on that one?
I'll start. And Beatrice obviously chime in. Yeah, I mean, the DEI initiatives should be in place for all companies, quite frankly. And, when you're talking about the employment side, you should make sure that you have a sound entire program for your organization. And obviously most organizations today have it as part of their philosophy, which is excellent. So with that in mind, what you traditionally want to see is if you're trying to reach certain groups, there are a lot of groups out there that are welcoming to companies that want to go into certain places and actually use job boards that they might have to post a job, or associate yourself and go out to your local ERGs, employee resource groups that are within your city. There's lots of one in most cities. There's all kinds of groups that have DEI initiatives that you can partner with, especially locally. We always say if you're putting up a store, you want to hire local folks because that's in the neighborhood by which that they operate. So I would encourage everybody, one, one, to have a DEI policy or initiative and philosophy in place, and then encourage you to reach out to groups that are more than welcome and more than willing to help you, with some of those employment needs.
Fantastic.
I would just add on that point, it's the DEI initiatives can be very important to welcome people from all walks of life into your business, but you just have to be careful as a business that you don't turn it into discrimination against, some groups, who originally had the power. You have to ultimately, there's state and federal laws against racial discrimination, gender discrimination, and so forth. And you want to make sure at the end of the day that your policies aren't, they call it reverse discrimination, but sometimes it opens a company up for lawsuits if they're explicitly providing benefits based on race or gender or some other protected status and kind of discriminating in the opposite direction. So it's kind of a fine line, but companies have to make sure that they are truly welcoming to all groups and not singling out any particular groups for a disadvantage in the way that the laws apply.
Just remember, if you offer it to one, you have to offer it to all. That's the way I always associate it. So any benefit.
Yeah. It's a great point. Before I jump to the next question, I believe our poll question has launched. So I encourage everybody to please answer that. That helps us make our content better for the next webinar. So we have the next Q&A question. As a vendor, I have to sign a lot of NDAs as part of working with customers. How valid / enforceable are they? Anybody want to jump on that one?
Raza?
Sometimes they might not be enforceable or valid, but I mean, at the end of the day, if you sign a contract, you're considered to be bound by its terms. So I think a lot of companies are kind of over-inclusive and, the amount of NDAs they get people to sign just because it can't hurt to have them sign it and it might protect them. So I would say if you're, as a company, considering NDAs, it generally pays to be over-inclusive. And if it turns out that some of them are not enforceable down the road, but that's, at least you made an effort to protect as much information as possible. But I would also say if you sign one of these documents, don't just assume that it's enforceable. It may very well not be, and a lot of companies use them in inappropriate circumstances. So if you're asked to sign something and you think it, doesn't make sense and there's going to be violations, based on what it says, definitely read it and, raise an issue. If you think you're going to be violating this agreement, you don't want to set yourself up for something where you get into liability because you signed something and it turned out it was over-inclusive. So I would just say read the documents you're asked to sign and raise an issue if you think there is a question that you're going to be violating this agreement.
And one more Q&A question while we're talking about confidentiality. Can you touch on non-compete clauses in conjunction with confidentiality agreements? You want to hit that one real quick, Raza?
Non-compete clauses, that's something where it's going to be state by state. It varies greatly. Some states, it's very difficult to enforce these agreements. Other states are a lot more open to them. So I would look at your state law on that issue because it varies widely.
But I know that I think they're outlawed in California now, and that's kind of the growing view across the country. So Roz is absolutely correct to make sure you check what your local law is in that regard. All right, we got to move on to how to conduct investigations. So why is it important to conduct an investigation when there are allegations of wrongdoing, and who do you involve? Jason, you want to handle this one?
Well, let's go with Beatrice first. And then
okay, there you go.
You can jump, sure.
I talked too much already.
Well, there's a lot of things that you want to do, some steps that you want to take. So the first thing you really want to do is, weed out the bad apples, as I like to call them. Is you want to, an investigation is going to help identify any individuals or any practices that can pose a risk to the organization. So, if you uncover misconduct, then you can then take corrective action promptly. You also want to make sure it's conducted well, that you're doing everything by the book, you're following protocol, you have a written process in place, because as you have seen probably nowadays, a poorly conducted, whether it's a investigation or a termination, it's probably going to show up on TikTok. So you want to avoid anything that will put your company in bad light and be all over social media. So that's something you want to make sure of. You also want to make sure that you are following, again, processes. You're keeping all the employees. You're being fair, and you're addressing any concerns. You are taking the allegations seriously, even if you don't feel that it's a warranted allegation. You still need to investigate it, make sure the employees feel that they're being heard, and then whatever the outcome is the outcome. So as far as who should be involved, you definitely want to involve, if you have HR. If not, legal counsel obviously is always important to get them involved, depending on what the investigation is. So there's other people that can be involved if you don't have HR, usually like your director, whoever the sort of top person at the organization is, somebody that can remain impartial to doing that investigation. Jason, if you have anything to add on.
Yeah, no, I mean, that was great coverage. Who to involve, you already mentioned it, HR, legal, start with those folks. And sometimes it goes to the manager first, and then the manager needs to right away report that to HR and ask for direction. And then HR is usually the ones that will handle it as far as the process goes. What I will say that needs to be enforced, or at least mentioned to people, is confidentiality during an investigation. A lot of times when you pull different people to get statements, you need to remind them that this is a confidential investigation, and they're not to disclose anything that they've said to whoever's investigating, because that could include up to and including discharge, is what we always used to say in HR, because you have to keep the confidentiality of the investigation, because you don't have the results, and you definitely don't want rumor mills going around the company. So it's really important that confidentiality is situated. Document. I can't say it enough. Make sure you're documenting all your questions, answers, time, dates, and then filing them in a secure location. These are not to be shared unless they need to be shared during investigation outcomes, or however. It's usually a smaller group of people during the investigation. And then sometimes when it's of like a higher level, let's say C-suite or above, you may have to get outside counsel. So that might be a requirement as well. Usually your in-house general counsel will give you that advice whether or not it needs to go out or not. So I would highly encourage, if that occurs, ask them for that advice, and they'll give you the direction.
And to your point as well, make sure you're only involving the people that need to know. People
Correct.
think they need to know, but they don't always need to know. They may want to know, but they don't necessarily need to know. So again, speaking to confidentiality, making sure you're only involving those that need to know, and that, again, you're holding the sessions in a private setting. You're not doing it. You're not discussing anything open in public spaces, even in open, common areas of the company. Just making sure to keep that confidentiality as tight as possible, and keeping it as close knit to who needs to be involved.
Sounds good. I think we covered a lot of what I was going to ask next, and that's when starting an internal investigation, what are you supposed to do? What do we know about confidentiality? Having the right team members there that are part of the investigation. Anything else to add on what to do to get started on an investigation?
I would think that, getting started, but once you determine, you have to determine at some point if the allegation is proven true based on what the investigation is. Sometimes, depending on the situation, you may need to have, like Jason's point, somebody outside to handle the investigation, to do the actual fact finding. Depending on what the situation is, if it's a C-suite person, you may not want the HR person doing the investigation. There may, be some issues there. So, again, remaining fair and objective and impartial, completing the investigation timely. You don't want it to drag out if you can avoid it for 6 months. You need to address it, investigate it, determine if it's actionable, if there's something that needs to be acted upon, and then determining what those steps are. Is it something that you can do a preventative something in the future where you need to change a process or you need to change a policy so that next time it doesn't happen again? Or is it something where you have to take some sort of disciplinary action, up to and including termination, those lovely words that HR folks we like to use? Again, depending on the severity of the situation, what's the appropriate action to take once it's determined?
Yeah. And just to add lastly is, once you've documented it, and storing it is important, but keep in mind, sometimes investigations could involve health related items of the employee that falls under HIPAA. So you need to remember that as well. You cannot be sharing certain information points, even in some of the cases, to other parts of the investigators on a need to know basis. So that is something that can be tricky. Your HR person should know how to handle that situation, but that's something I've seen companies get dinged on because they've shared health information when it wasn't necessary for certain individuals. And I love you CEOs out there, but sometimes we can't share the information until the end of the investigation. So please let us do the investigation, and we promise we'll get you the result. So I get asked that a lot from CEOs, and God love them, but I have to follow protocol.
All right, and now let's skip to whistleblower complaints. What are the best practices for handling whistleblower complaints in the cannabis industry? Raza?
Sure. So these best practices, they really apply to all industries. But I think for whistleblower situations, there's kind of a lot of incentives for a company to handle these badly. In general, if there's not policies in place, people naturally want to protect themselves. They want to protect their friends and so forth. But handling these whistleblower situations badly can create a lot of liability for a company when it comes out that it was put on notice of these problems and then it ignored them or tried to bury them. So it's really important to have processes, policies in place that can serve as sort of a guide for how to address these, because if left to their own devices, people often do things in a way that's bad for the company. So just to start out with having the employee handbook, just policies and procedures for handling these complaints. So it's clear how to report them, who to report them to, who's responsible for receiving and investigating them, and making clear that confidentiality will remain in place to protect people so they're not worried about going to HR to discuss these problems. Again, this should be done at the orientation in the handbook policy documents, so it's clear to everybody. And then during the investigation, limit the number of people who are privy to the information on a need-to-know basis. Sometimes people will start getting blowback, if they're investigating something, and people are trying to protect themselves or other people. So try to do this in a way where whoever's looking into it isn't going to tip off everybody in the company about what's going on. But it's important to investigate them promptly. If there's an allegation of something that's illegal, it's important to document that you looked into it and either determine that it wasn't credible or that there was something to it. Like was mentioned, sometimes it's helpful to bring in outside people. Sometimes it can be too political within a company. People have particular loyalties and interests that'll stop them from really doing a honest investigation. But if you bring in an outside law firm or other group to come in, sometimes they can get to the truth easier than people who are kind of entangled in these relationships. And then in terms of the investigation, keep some kind of report, documenting what was the complaint, when was it received, what were the steps you took during the investigation, and what was the outcome. This can be important in any litigation to have this written down to show what actually happened. So it's not just a he said, she said kind of situation. And then protecting against retaliation is important too. A lot of employment lawsuits end up with a disgruntled employee, who is fired for reporting problems. And, that creates a wrongful termination retaliation situation, which we'll get into, I believe, in the next situation. So if someone did recently make a report of illegal activity and there's some credibility to it, maybe don't fire them really soon after that, because that just looks really bad, the timing of it all. Termination is appropriate sometimes, even for employees who have raised issues. But it's important, if that's the case, to make clear in the documents the reason for the termination. That had nothing to do with the reports they made, but some other independent basis. That's why performance reviews and that kind of thing are important, so you can go back and point to the fact that any kind of discipline was actually due to a legitimate reason and not because this person has raised a complaint. And then any whistleblower situation, it can help to consult with legal counsel to find out what to do. As mentioned, sometimes these are sticky situations involving interpersonal loyalties and that kind of things, and people could use some kind of direction as to how to handle them properly. So talking with an attorney, if you're in one of these situations, can help in terms of just walking you through the steps and what you need to document, and what some kind of red flags are that you should avoid. And yeah, just if you find out that there was a problem, then take corrective action. This can include disciplinary action, terminations of people who are committing illegal activity, putting in place new policies to prevent it. But if you can show that if there was a problem, if you took steps to address it, that can reduce liability going forward.
And document, right?
Absolutely.
And we have a question on the Q&A, and I'm not familiar with this case, but any thoughts on the Olenowski versus New Jersey ruling and the wire requirements, et cetera, in the workplace? Anybody aware of that? Well, I will take note of it, and we will make sure we get this question answered for you the best we can. So now on to you've already conducted your investigation, and now it's time to terminate somebody. So we're on to terminations. What is considered a wrongful termination, and what are the legal ramifications?
So wrongful termination, most states, they have the default rule is at-will employment. And some people understand this to mean that you can fire someone for any reason at all or no reason at all. But there's important caveats to that. At-will employment, you are allowed to terminate someone for many reasons, but not for a reason that violates the law. You can't do it for a discriminatory reason or for retaliation against them making a report of illegal activity. The other exception to the at-will employment is if the person has an employment contract, that can provide grounds for wrongful termination. Sometimes there's an employment agreement signed at the beginning of employment that says a person can only be terminated for a cause, and that can be defined in different ways. So anytime there's a termination, you want to look at these points to make sure they're not wrongful. First of all, that there's no inference that can be drawn that this was discrimination or retaliation. And then also that if person did have an employment agreement, take a look at that and see if there's any discussion of the reasons they could be terminated, the process for termination, and so forth. But just in terms of the categories, one category is discrimination, termination based on a protected characteristic, such as race, color, national origin, sex, age, disability, religion, or pregnancy. That's unlawful under various federal and state laws. Sometimes it's not possible to immediately tell if there was for a discriminatory reason, but if there's examples someone can point to of language you use showing a bias against particular groups, that can be a problem. Also can be a problem if there's a pattern that that you're firing women on a much greater rate than men, for similar types of things, or one race is being disciplined, terminated at a higher rate than others. Try to make sure people in the workplace are not using language that can be interpreted as bias. Discourage that, and look at the numbers that what you're doing isn't adversely impacting one group based on their immutable characteristics, and that it's a fair application of rules to everybody. And then the other big category is retaliation. If you fire someone who's made a whistleblower complaint, we just talked about that can be a problem. Or someone who reported workplace harassment or discrimination, or if they filed a complaint with a government agency, or if they participated in an investigation and made statements that some people don't like. It's important to think twice about firing someone like this, because that can create a lot of liability. And then breach of an employment contract, we talked about that. If someone has a contract and the employer violates that contract, it can be considered wrongful termination. If they're doing it without cause, when the contract specifies that it can only be for a cause, or if you didn't follow certain agreed upon termination procedures. And then there's another type of wrongful termination where it's not exactly a termination, but it's considered a constructive discharge, when an employer really puts these onerous conditions on an employee that becomes so intolerable that a reasonable person would feel compelled to quit the job. So if an employee engages in protected activities, making a complaint, a whistleblower, and so forth, and you start treating them differently, that can also be a problem. And what happens if there is wrongful termination? You can end up with civil lawsuits. The employee can seek damages for lost wages, emotional distress, punitive damages sometimes. A court might order that the employee be reinstated. They might order that the employee get paid their back pay and benefits. Sometimes the employer could be responsible for attorney's fees and court costs for the employee. And it also just looks bad for the employer's reputation and can lead to negative publicity. So how do you do a termination? Just it's important that you go back to the handbook, look at the procedures, make sure you're following the right process, that if you're terminating someone, it's documented, the non-discriminatory reasons, non-retaliatory reasons are well documented. And then sometimes it helps to seek legal counsel, just run it by an attorney before you actually do the firing, to make sure that it's documented properly. And also upon termination, there's usually certain payment obligations about payment of wages and so forth. Sometimes it has to be done on a relatively quick basis. So kind of come up with a plan before the termination, and then make sure that you're following that process for payment of wages and wrapping up any loose ends. So you just have a procedure in place instead of making kind of emotional based decisions that can then lead to kind of rippling liability.
I want to go to our HR pros because we're running out of time here. But so Jason and Beatrice, if you want to jump on this one, what are some of the best practices that you've employed for delivering termination news to an employee?
I can jump in and start since we were short on time. I'm happy to jump in. So one thing is you want to look at timing. It's Fridays. It used to be everything happened on a Friday afternoon, 5 o'clock, 4:30. Fridays really aren't good and aren't recommended best practices. It's harder to reach. If they, let's say they're having some emotional issues, it's harder to get. If they need to get in to see someone, just support services are harder to get on a Friday afternoon. So earlier in the week is better. Either earlier in the day, maybe before they've even started their work day, or whenever there's going to be the least amount of employees at work, when you can have the least amount of disruption. Try not to do it around like their birthday or right before a big holiday. Those are kind of some things to kind of think about. Make sure you have a private location, maybe even a conference room instead of your office. Give them a few minutes at the end of the meeting if they need to compose themselves, if they've gotten upset. Be professional, allow them to maintain their dignity. But you also want to prepare what you're going to say and be concise and stick to the point. Now is not the time to go back and forth with well, why am I getting terminated? But I should do this. Like that you need to be very concise and say, be direct and say the company's decided to let you go. Today is your last day. Thank you for your contributions while you were here. We wish you well. Make sure you have someone as a witness. You always want to have another person in the room with you during that termination meeting. And then just be prepared to know how they're going to react. You may expect one person to get really upset and they're calm, and another person that you thought was going to be not having any issues, go off the rails. So if you think that the employee may get hostile, have security or even law enforcement nearby, just kind of waiting in the wings. Make sure you talk about any type of, if there's a severance package or any benefits they may be eligible for COBRA, 401k rollover. Think about what you need to do while they're in the meeting. Is somebody going to be gathering their belongings? Are you going to allow them to go back to their desk? Maybe only gather the critical, the important things they need: car keys, purse, wallet, whatever the case is. And then somebody else can box it up, or you can schedule a time for them to come back in after hours. So, they're not having to box up their stuff with everybody staring at them. Make sure you shut off access, badges, IT, get with IT, all of that. Again, payroll, determine about severance, let them know that's ahead of time, and make sure you have a policy that you apply consistently as far as what you're paying out for severance. And that's a great time to consult one of our great friends at Zuber Lawler about setting up a severance agreement if you don't have that already in place. And then lastly, make sure you're communicating to the team members that are left, who's going to pick up the responsibilities depending on their role. What happens now that that employee is no longer there. So that was a lot of stuff in a really short period of time. I kind of try to cram it in. Jason, you have anything to add?
I'm just going to say ditto, and just keep in mind these are people. So put a little human aspect in it. Put yourself in their shoes. Be thoughtful. It's a hard day for everybody. It's hard for the deliverer. It's hard for the receiver. So, but Beatrice covered it. So thank you.
Well, I think that's our time. And I believe, thank you to all the participants who watched this webinar today. You should have all of our email addresses. We'd love to hear from you if you have any follow-up questions that you want to ask of any of us. So we'd love to hear from any of you participants out there. If you haven't answered the poll question, please do that right now before we go off the air here. But thank you very much, and thank you to my esteemed panelists for participating. And I know I learned a lot today, so I hope everyone else did too.
Thank you, guys.
Thanks, everybody.
Thank you, everyone. Bye.
Thank you.
Thank you.